Appearance.
With due respect to my lady, my name is Osita Mbamalu. I appear for the claimant. With me are my learned friends.
Yes.
Damilola Ojopagogo. And Iyinoluwa.
The name
Iyinoluwa. Iyinoluwa.
Yes.
Mwaoje. Mwaoje is Mwajei. Mrs. Our appearance is for the claimant.
With the greatest respect to your lordship, my name is Ayo A. Olorunfemi. With me are my learned friends, Paul Omaidu Esquire and Folashade Callisto, Mrs.
Callisto, is this start with a C or K?
C, my lord. C, my lord. Yes. We appear.
Can you spell it for me, please? Callisto.
C-A-L-L-I-S-T-O. We appear for the defendant, my lord. Defendant.
In reading the judgment, I shall simply read the introductory portion and then go straight on to the decision portion. So that is because of the length and because of the interruptions with the network.
As the court pleases.
Judgment. The claimant filed this complaint against the defendants on December 27, 2013, together with the accompanying processes. By an amended complaint, accompanying processes filed on 20th February 2018, she is seeking the following reliefs. 1, a declaration that the determination of the claimant's employment by the defendant's letter dated 24th October 2014 during her maternity leave period is unlawful or illegal, and same was discriminatory against her on the ground of her gender and or pregnancy, and therefore unconstitutional, null and void, and in violation of international treaties and conventions. 2, an order for payment of exemplary or aggravated damages to the claimants by the defendants in the sum of 150 million naira. The first and second defendants filed an amended statement of defense and a counterclaim, together with the accompanying processes on 16th March 2018. The counterclaimed as follows. 1, refund of the total sum of 12,973,352 naira made up as follows. A, advertorial consultancy and FS 504659. Rent and furnishing of apartment, 5 million. Salary tax inclusive, 2,250,000. Hosting the claimant for lunch at different dates during the interview, 83,693 naira. Providing water treatment, 135,000. Costs of this action, 5 million. The said sum together with 25% per annum from 2013 until judgment, and thereafter at 6% interest per annum until liquidation. I will go straight to the decision. I have carefully considered the originating processes, the evidence, the submissions of counsel and authorities relied on in the final address. At this juncture, I will begin with the preliminary issue, stroke objection by the defendants, wherein they contend in their pleadings that they have been improperly impleaded as parties because they are not the legal entity known as Starling School, with whom the claimants allegedly contracted. Exhibit C2 is the certificate of registration of the business name Starling School, and the first and second defendants are named as partners. Exhibit C1 is a statement on oath sworn to by the first defendant on 28 February 2014, in which she made the following deposition: that Starling School was registered by myself and my husband, Mr. Augustine Olo, in 2005, but I am the director and the administrator of the school, as I run and maintain the school. In cross-examination, the first defendant stated, and I quote, Mr. Augustine Olo is a nominal proprietor. Exhibit C1 and C2 and the oral evidence of the defendants reveal that the defendants are partners and proprietors of Starling School. The defendants based their objection on the provisions of Order 13, Rule 22 of the NICN Rules of Court, reproduced as follows, and I quote, any two or more persons claiming or alleged to be liable as partners and doing business within the jurisdiction may sue or be sued in the name of the firms, if any, of which they are partners, when the cause of action arose, and any party to that action may in such cases apply to the judge for a statement of the names and addresses of the persons who were partners in the firm when the cause of action arose, to be furnished in such manner and verified on oath or otherwise as the judge may direct, end of quote. The word may is not only, the word may used is not only permissive, but applicable only to permit an action by or against the partnership, and is not to prohibit the claimant from instituting an action against the defendants who as natural persons are juristic persons that can sue or be sued. See Fawaimi versus NBA. Also see the commentary in on the impartial provision under Order 81, Rule 1, Rules of the Supreme Court of England. Furthermore, Order 13, Rule 25 of the NICN Rule states, and I quote, the above rules in this part of this order shall apply to proceedings between a firm and one or more of its partners, and between firms having one or more partners in common, provided such firm or firms carry on business within the jurisdiction. The defendants are juristic persons, the proprietors running their business at Starling School. By the deposition of the first defendant, she is the director, the administrator, and she runs and maintains Starling School. The pleadings and evidence reveal that the first defendant had personal dealings with the claimant, pre-employment, during the employment, and post-employment. I find that the first defendant also personally signed the employment contract on behalf of Starling School. I hold that the proper parties are before the court. The court has jurisdiction to entertain this matter. This objection is overruled. The law is settled that whoever desires the court to give judgment as to any legal rights or liability dependent on the existence of facts which he asserts must prove those facts exist. See section 1311 and 2 of the Evidence Act 2011. Also see Calabar Cooperative Limited versus ECHO. The relevant documents the parties have placed before the courts include the contract of employment, Exhibit C3 and D1, the claimant's marriage certificates, Exhibit C4 and D14, birth certificates, Exhibit C6, email from Mr. Jonathan Ogidinwakwo, C15, Federal Medical Center Medical Report, C7, claimant's CV, C14, claimant's application form, Exhibit D31, claimant's certificates, Exhibit 43 to 48, reference mails, Exhibit C7 and D2, termination letter, Exhibit D5, response to termination letter, Exhibit C42, medical certificate, C53, C54, D7, request for a different living place in Lekki, Exhibit C39, first defendant's academic certificates and workshop attendance certificates, Exhibits D24 to D26, and D28 to D30. The issues that arise for determination are as follows. 1, whether the claimant misrepresented her name in executing the contract of employment. 2, whether the termination of the claimant's employment by the first defendant after childbirth and while on maternity leave was discriminatory on grounds of gender and or pregnancy, unlawful and in violation of constitutional provisions, international conventions and treaties. 3, whether on the pleadings and evidence, the claimant ought to be entitled to the reliefs she is seeking. 4, whether the defendant has proved the counterclaim. Learned Senior Counsel to the defendants has submitted that the defendants are not bound by the terms of the employment contract and that it cannot be the foundation of any valid court action because the claimant misrepresented her name and qualifications, and as such, it is an illegal contract and void ab initio. The basis for the allegation of misrepresentation of name by the defendants is that the claimant was not legally married to her husband, Jonathan Ogidinwakwo, as of February 2013, when the employment contract was executed by the parties, and that her true and correct name is as seen on her curriculum vitae Nicolene E.W. Tresford. Therefore, she had no right to include Ogidinwakwo as part of her name. The claimant's evidence is that she and her husband had been living together in Holland since 2012, and that, I quote, as a Dutch citizen, no marriage is required for me to live with my husband or to address myself as his spouse in Holland. And after our cohabitation, I had a choice of whether to use my maiden name, Tresfron, or my husband's last name, Ogidinwakwo, or a combination of both. My husband and I are happy with this state of affairs. This evidence is unchallenged by the defendants. The employment contract is between Sterling School and Mrs. / Miss Nicolene E.W. Tresford Ogidinwakwo. The claimant's names on the employment contract are her maiden name and her marital name together. I find that the claimant did not misrepresent her name to the defendants, be it Mrs. or Miss, as the first defendant knew the claimant's personal relationship status with her husband, Jonathan Ogidinwakwo, at the material time. The first defendant or the defendants were therefore not deceived when the claimant signed the employment contract as Nicolene Tresford Ogidinwakwo. and she signed as Priscilla N. Olo, Director on behalf of Starling School. Furthermore, there's no evidence that the claimant drafted the employment contract. Rather, the employment contract was prepared by the defendants and given to the claimant, who came into Nigeria for the interview on the 13th of February 2013 to, I quote, read, approve, accept, and execute on the 14th of February 2013, as clearly seen on the execution portion of the employment contract, and in the presence of the defendant's recruiter, consultant, Mr. Armstrong Samuel Adai. Clause 17.4 of the employment contract provides that misrepresentation may be a ground for termination of the employment by the employer. This provision relates to discipline and disciplinary measures, and not to the validity of the employment contract to render it illegal or void ab initio, as submitted by the defendants. I hold that the employment contract is valid and it is binding on the parties. The defendants have made the claimant's name and marital status an issue in this dispute in paragraphs 5, 6, and 7 of the amended statement of facts as follows. 1, as follows. 5. In further denial of paragraph, I quote, in further denial of paragraph 1 of the amended statement of facts, the defendant states that contrary to the claimant's assertion, she was not married to Mr. Jonathan Ogidinwankwo at the material time when she executed the purported contract of employment with the school and held herself out as such. 6. Further to the preceding paragraph, the defendant averred that the claimant's true name, when she applied for the position of the head teacher of the school, executed the purported contract of employment, was Nicoline Emile Willem Tresfon, and not Nicoline Tresfon Ogidinwankwo, as she was not married to Mr. Jonathan Ogidinwankwo as at 14 February 2013. The defendant's opinion shall rely on the biodata page of the claimant's international passport at the trial. 3. 6, 7. It was subsequent to the execution of the purported contract of employment that the claimant allegedly got married to Mr. Jonathan Ogidinwankwo in Holland on the 20th of April 2013, which she later remarried the same Mr. Jonathan Ogidinwankwo in Nigeria on the 23rd of May 2013. The defendants hereby plead and shall rely on the claimant's 2 marriage certificates at the trial. In my considered view, this is simply a sanctimonious issue on morality by the defendants. This is because in the employment contract, marital status or the state of being married or unmarried is not a term of the employment contract. The claimant, in her reply, joined issues with the defendants, and in paragraphs 4, 5, and 6 of her additional statement on oath, testified as follows. 4. In response to the allegation that I misrepresented my name, I state that my husband, Jonathan Chukwuma Ogidinwankwo, and I had been living together in The Hague, Holland, since 2012. And on 29th October 2012, we celebrated our marriage at Ogidi's compound, Umuobia, Olokoro, Umuahia, South Abia State, under native law and custom. The subsequent celebration of marriage at Christ Embassy Church, The Hague, Holland, was by choice. Copies of our native law and custom and church marriage certificates given to the first defendant are now produced, shown to me. Wedding photographs also are now produced, shown to me. 5. As a Dutch citizen, no marriage is required for me to live with my husband or to address myself as his spouse in Holland. And after our cohabitation, I had a choice of whether to use my maiden name, Tresfon, or my husband's last name, Ogidinwakwo, or a combination of both. My husband and I are happy with this state of affairs. 6, the marriage celebrated by the parties at the marriage registry in Nigeria during the school's midterm break on 23rd May 2013 was at the request of defendants for evidence of marriage celebrated in Nigeria to save sterling school costs that may ordinarily be incurred in applying for expatriate quota if I'm not the wife of a Nigerian. Hence, a copy of my registry marriage certificate was also delivered to the first defendant upon my return from Eastern Nigeria. Paragraph 6 of the claimant's deposition is uncontroverted and it speaks for itself. The claimant's identity is not in question. There is no law in Nigeria that prohibits a female, a married woman, from answering her maiden or family name if she so desires, or a combination of her maiden and marital name, or her marital name alone. I find this issue raised by the defendants is because the claimant is female. In other words, it is because of her gender that her name and marital status is being made an issue. The claimant has complained that her employment was terminated while she was on maternity leave, and that the termination is connected to her gender and her pregnancy, which is discrimination and in violation of Section 2 of the 1999 Constitution, international treaties, and conventions. The defendants denied this and state that the claimant's employment was terminated because she misrepresented her name and misrepresented that she was a teacher at Dark Kinder Central, her immediate past employers, where she was a child care worker. I have already found above that the claimant did not misrepresent her name. I will reproduce the letter of termination written by the first defendant. Dear Mrs. Nicolene E.W. Tresfon Ogidinwa, for termination of appointment. Please be informed that your services are no longer required by the school. Reports that we received from Dark Kinder Central, where you claimed to have worked as a teacher and supervisor, reveal that you were a child care worker and worked at various child care centers. It is obvious that Dark Kinder Central is definitely not a school, as they said so in a subsequent mail to us. The school resumed on the 9th of September 2013, and you did not report for duty and have since abandoned your job. Consequently, in the exercise of our rights under clause 1.3 and 19.4 of the contract of employment, we regret to inform you that the contract is hereby terminated. The accounts department has been directed to pay to you the sum of 690,000 naira, being 2 months' salary, less taxes on compassionate grounds. Thank you. Yours faithfully, Mrs. Priscilla Olo, Director. The letter speaks for itself. The first defendant has given 2 reasons in the letter of termination. The law, see your Latin versus NISA Council, international best practices in labor, employment, and industrial relations imposes on the defendants a duty to justify the reason given for the termination of the claimant's employment. It is the law that whoever desires the courts to give judgment as to any legal right or liability dependent on the existence of facts which he asserts must prove those facts exist. Section 131 and 2 of the Evidence Act 2011, also see Calabar Cooperative Limited versus ECO, It is also the law that civil suits are decided on the balance of probabilities, on the preponderance of evidence. The burden of proof is not static, but shifts from side to side. The onus of producing further evidence is on the person who will fail if such evidence is not adduced. See the cases of Danjuma versus SCC Nigeria Limited, Osuji versus Ekiocha, Fadala versus Arewa Textile Limited. I will begin with the first reason given, the reports from Dark Kinder Central. The uncontroverted facts reveal that the claimant was head-hunted by the defendants and their recruiter, who saw her motivational letter, Exhibit C13, and her curriculum vitae, Exhibit C14, posted online for a position as a teacher in the Shell Petroleum Development Company in Nigeria. She was contacted by the recruiter and first defendant and invited to apply to Starling School. She had several telephone and video interviews with the first defendant and the recruiter on her curriculum vitae and credentials. Thereafter, the defendants invited her to Nigeria at their expense for a presentation and interview on 13 February 2013, where they examined all her credentials, referral letters, and interviewed her on her educational qualifications, her training, teaching, and management experience. The claimant was successful at the interview and she was offered the job of head teacher. The employment contract was signed the following day, 14 February 2013. The claimant holds a Bachelor of Arts, a bachelor's degree in languages and European studies, a higher diploma in pedagogy and child development, certificate in child education and child care management from Dark Child Care and Pedagogy Institute, and several other training certificates in communication, child education, and development. I find that the claimant is very well educated. The claimant states in her curriculum vitae that she is, and I quote, currently enrolled for rapid course in primary school teaching, and that her employment from 2006 to present, in quotes, is teacher and activity supervisor at Dark Child Care and Pedagogy Institute. The underlining is mine. Part-time teacher for creative workshops at Pink Pepper Language and Creative Workshop Institute. Primary school teacher at Montessori Preschool, Walsdorf. The claimant in her application form, Exhibit D31, also states that she's a teacher and activity supervisor. I find from the claimant's curriculum vitae that she never stated that Dark Kinder Central is a school. In cross-examination, the claimant testified that she was a teacher at Dark. The first defendant has put in evidence her own educational qualifications and certificates. A BSc degree in education, master's degree in business administration, and other certificates courses she has attended locally and in the United Kingdom. I therefore find the first defendant to be a very experienced educator and very well educated. She was a member of the interview panel, and she read the curriculum vitae of the claimant. She, along with others, decided the claimant was suitable for the job and offered her the job. The first defendant, in her letter to the claimant, dated 8th October 2013, Exhibit D4, stated thus, and I quote, "In effect, you have only served a probationary period of 3 months, which you worked effectively, and the month of August when the school was on holidays. This statement is evidence that the first defendant found the claimant to be suitably qualified and competent to be head teacher. The first defendant in cross-examination stated that she wrote a letter on 3rd July 2013 requesting for a reference from DAC. There's no evidence of this letter before the courts. The responses by DAC to her inquiries are dated Tuesday, October 8, 2013, and Wednesday, October 9, 2013, as seen in the email trail, Exhibit D2. The HR advisor of DAC states, and I quote, "In your letter, you refer to our company as school. But I must say that our organization, DAC Kinder Central, is a childcare organization, daycare for children in the age 0 to 4, and after-school care activities for children in the age 4 to 12. This, I find, confirms the claimant's statement in her curriculum vitae, DAC Childcare and Pedagogy Institute. The HR advisor also states that the claimant worked within the organization from September 2008 until 1st of March 2013 as a childcare worker and was suitable for the job. Now, how does the first defendant, who is a successful and exposed educator, expect this court to believe that the job of childcare does not include teaching, which is imparting knowledge, particularly with the educational qualifications of the claimant obtained in a European country? Put in another way, does the first defendant expect this court to believe that she is unaware of the fact that childcare is not devoid of teaching, particularly as she has stated to the claimant in Exhibit D for that, I quote, "You have only served a probationary period of 3 months, which you worked effectively, and the month of August when the school was on holidays." I find from this statement that the claimant worked effectively as head teacher. It is therefore my considered view that the claimant, as childcare worker, is also a teacher. This is evident from the commendation by the first defendant. I find that there was no misrepresentation by the claimant that she worked as teacher and activity supervisor at DAC Childcare and Pedagogy Institute. The defendants have failed to justify the first reason they have given for terminating the claimant's appointment. I so hold. The second reason given for terminating the claimant's appointment is that she abandoned her job. The evidence adduced is that the claimant had informed the first defendant that she was pregnant with expected delivery date in October 2013, and that she planned to have her baby in Holland. The school closed for holidays between July and September 2013. After the 4-week summer school organized by the claimant, she vacated her official accommodation so that it could be fumigated, and she traveled to Abia State. While in Abia State, the claimant took ill and was admitted at the Federal Medical Center, Umuahia, and on 8th August 2013, she had emergency cesarean section to deliver her preterm baby boy at 32 weeks with a birth weight of 1.6 kg. The baby, Exhibit C6, the baby was placed in an incubator in the intensive care unit at the Federal Medical Center, and he also received medical treatment at Medic Angel Clinic, Ikeja, Lagos. The claimant's husband informed the first defendant of the birth of the baby, and the medical condition of the claimant by Exhibit C5. And first defendant congratulated the claimant. The claimant wrote a letter to the first defendant on 8 September 2013, Exhibit D3, requesting for a suitable and standard accommodation for purposes of the health and well-being of her and her baby as recommended by the doctors for various medical reasons. She then traveled to Holland in mid-October 2013 during her maternity leave for better medical care for herself and her son. The medical certificate of the doctor in The Hague, dated October 15, 2013, which is Exhibit C53, states that because of medical reasons, she's not able to work and needs at least 2 months to recover from the cesarean section and the effect of malaria infection. The claimant also testified that her son was admitted in the hospital at Holland from 18th October to 20th December 2013, during which he had surgical operation on his kidney, and that the letter determining her employment was written and delivered to her in Holland during the period of her maternity leave. All of this evidence is unchallenged, and the court must accept it. See the case of Ogbe versus Asade, see also Omoregbe versus Lawani. I find that the claimant, by reason of the emergency cesarean section carried out on her on 8 August 2013, commenced her maternity leave on that day. And she's so deemed to have commenced leave on that day. And this fact was known to the first defendant. I therefore hold that the claimant did not abandon her job. Rather, she could not resume duty because she was on maternity leave. I so hold. The defendants have not justified the second reason they have given for terminating the claimant's employment. By the terms of the employment contract, the claimant's probation was for an initial period of 6 months. She was therefore on probation at the time this dispute arose on 24th October 2013, when the first defendant terminated her employment. The question to be answered is whether Nigerian labor law, international conventions, and international best practices permits the defendants to terminate the claimant's employment when she is on maternity leave. This is crucial as the claimant has alleged discrimination against her on the grounds of her gender and/or pregnancy. Section 254C1, F, G, H, and 254C2 of the 1999 Constitution as amended empower this court as follows, and I quote, notwithstanding the provisions of sections 251, 257, 272, and anything contained in this Constitution, and in addition to such other jurisdiction as may be conferred upon it by an act of the National Assembly, the National Industrial Court shall have and exercise jurisdiction to the exclusion of any other courts in civil causes and matters relating to or connected with unfair labor practice or international best practices in labor, employment, industrial relations matters, relating to or connected with any disputes arising from discrimination or sexual harassment at the workplace, relating to or connected with or pertaining to the application or interpretation of international labor standards. 254C2. Notwithstanding anything to the contrary in this Constitution, the National Industrial Court shall have jurisdiction and power to deal with any matter connected with or pertaining to the application of any international convention, treaty, or protocol of which Nigeria has ratified relating to labor, employment, workplace, industrial relations, or matters connected therewith. Having been so empowered, the court has a duty and an obligation to apply international conventions and international best practices alongside Nigerian labor law in the resolution of labor and employment disputes, as decided by the Court of Appeal in Sahara Energy Resources Limited versus Oyebola. I will therefore have recourse, particularly to the United Nations Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, ILO Discrimination, Employment and Occupation Convention 1958, number 111, which have both been ratified by Nigeria and are in force. ILO Maternity Protection Convention 1919, number 3, and the Revised Convention 2000, number 183, which are evidence of international best practice, and Section 54 of the Labor Act in the resolution of this dispute. The Supreme Court in Abacha versus Fawemi has held that, and I quote, conventions and treaties create rights and obligations, not only between member states themselves, but also between citizens and member states and between ordinary citizens. And that the spirit of a convention or a treaty demands that the interpretation and application of its provisions should meet international and civilized legal concepts, end of quote. Furthermore, by the provisions of Section 19C and D of the 1999 Constitution, the foreign policy objectives shall be respect for international law and treaty obligations and elimination of discrimination in all its manifestations. Section 54(1)(a) and B and 4B of the Labor Act provide, and I quote, in any public or private, industrial or commercial undertaking, or in any branch thereof, or in any agricultural undertaking or any branch thereof, a woman shall have the right to leave her work if she produces a medical certificate given by a registered medical practitioner, stating that her confinement will probably take place within 6 weeks. A woman shall not be permitted to work during the 6 weeks following her confinement. 4, where a woman is absent from her work in pursuance of subsection 1A or B of this section, or remains absent from her work for a longer period as a result of illness, certified by a registered medical practitioner, to arise out of her pregnancy or confinement and to render her unfit for work, then, until her absence has exceeded such a period, if any, as may be prescribed, no employer shall give her notice of dismissal during her absence or notice of dismissal during her absence. Article 4 of the ILO Maternity Protection Convention 1919 states, where a woman is absent from her work in accordance with paragraphs A or B of the Article 3 of this convention, or remains absent from her work for a longer period as a result of illness medically certified to arise out of pregnancy or confinement, and rendering her unfit for work, it shall not be lawful until her absence shall have exceeded a maximum period to be fixed by the competent authority in each country for her employer to give her notice of dismissal during such absence, not to give her notice of dismissal at such time that the notice would expire during such absence. These provisions stipulates that a woman on maternity leave shall not be dismissed or given notice of termination of her appointment. In other words, any action to be taken against a woman on maternity leave is to be suspended by the employer until the expiration of her maternity leave and she returns to duty, irrespective of whether she is on probation or she's not on probation. This is the law. The defendant's lawyer in his letter, Exhibit D12, mentioned that the claimant informed the defendants she will have her baby in Holland, take her leave at the time of her delivery, and continue her job on her return. I find that the claimant's employment was terminated after she wrote to the defendants on 8 September 2013, requesting for a different and suitable living accommodation in Lekki, re-evaluation of her health insurance, and work vehicle. This was before she returned back to work. The first defendant, by her letter dated 8 October 2013, the first defendant responded by her letter dated 8 October 2013, and on 24th October 2013, the claimant's employment was terminated. I have no doubt in my mind that the claimant's employment was terminated as a result of gender issues, which are pregnancy and childbirth, her name and marital status. The first defendant in Exhibit C1 made the claimant's pregnancy an issue by stating that she concealed it and is not entitled to maternity leave while on probation. These issues are also mentioned in Exhibit D12, written by her lawyer. But the claimant's evidence is that she didn't know she was pregnant at the time she was interviewed. And once she found out, she informed the first defendant. I hold that the termination of the claimant's employment when she was on maternity leave is unlawful, and it is in violation of international conventions and treaties and Section 54 of the labor law. Article 1A of the ILO Discrimination, Employment and Occupational Convention number 111 states, and I quote, "For the purpose of this convention, the term discrimination includes any distinction, exclusion, or preference made on the basis of race, color, sex, religion, political opinion, national extraction, or social origin, which has the effect of nullifying or impairing equality of opportunity or treatment in employment or occupation." The United Nations Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, defines discrimination as, and I quote, "any distinction, exclusion, or restriction made on the basis of sex, which has the effect or purpose of impairing or nullifying the recognition, enjoyment, or exercise by women, irrespective of their marital status, on the basis of equality of men and women, of human rights and fundamental freedoms in the political, economic, social, cultural, civil, or any other field." The claimant has reasonable grounds to believe that her pregnancy and childbirth, her name and marital status, and her way of life and culture as a Dutch woman have disadvantaged her in connection with her employment, resulting in the loss of her employment. This is an act of discrimination. The right to work with dignity is a universally recognized basic human right. See the Supreme Court of India decision in Vishaka and others versus State of Rajasthan. Articles 2 and 5 of the African Charter on Human and People's Rights Ratification and Enforcement Act provides every individual shall be entitled to the enjoyment of the rights and freedoms recognized and guaranteed in the present charter without distinction of any kind, such as race, ethnic group, color, sex, religion, political or any other opinion, national and social origin, fortune, birth, or other status. 5, every individual shall have the right to the respect of dignity inherent in a human being and to the recognition of his legal status. All forms of exploitation and degradation of man, particularly slavery, slave trade, torture, cruel, inhuman, or degrading punishment and treatment shall be prohibited. In applying these 3 instruments, I find that the claimant's rights against discrimination in the workplace has been violated, and I so hold. The claimant has asked for an award of exemplary and aggravated damages. Exemplary damages are awarded in very restricted and enumerated situations as a punitive measure where malice or gross disregard for the law is proved. So the case of Chief Williams versus Daily Times of Nigeria, GFKI versus NITEL. Learned Senior Counsel to the defendants has submitted that the sum of 150 million has no factual or legal basis, as the measure of damages is prima facie the amount that the claimant would have earned had the employment continued according to the contract. Section 7(6) of the National Industrial Courts Act empowers the courts to have due regards to good or international best practice in labor or industrial relations. And what amounts to good or international best practice in labor is a question of fact. In constraining this provision, together with the constitutional provision in Section 254C1F of the Third Alteration Act 2010, the Court of Appeal in Sahara Energy Resources Limited versus Oyebola Supra succinctly stated the legal position of these new provisions in the determination of the issue of quantum of damages as follows, and I quote, "The above provisions enjoin the National Industrial Court in the exercise of its jurisdiction to have due regard to good or international best practices in labor or industrial relations. The importance of this novel provision, in my deferential view, is that the National Industrial Court, in considering the measure of quantum of damages, is to do so in accordance with good or international best practices in labor or industrial relations, which shall be a question of fact. It will be stating the obvious to say that prior to the third alteration, when employment and labor matters were handled by the high courts, there was no obligation to apply and follow good or international best practices. It is an innovative provision which seems to be directed at enthroning an entirely new employment and labor jurisprudence. It will be disregarding this innovation if we continue to deal with the measure of damages in total disregard of the changes wrought to the law by legislation. The proper attitude of the court when confronted with an innovation introduced by way of an amendment to an existing law or a new statute simpliciter, in this case, the third alteration to the 1999 Constitution and the National Industrial Courts Act 2006, was enunciated in the case of Bank of England versus Bagliano Brothers, per Lord Herschel, as follows. I think the proper course in the first instance is to examine the language of the statute and to ask, what is the natural meaning uninfluenced by any considerations derived from the previous state of the law? and not to start by inquiring how the law previously stood, and then assuming that it was probably intended to leave it unaltered, to see if the words of the enactment will bear an interpretation in conformity with this view. The above passage was quoted with approval by the Supreme Court in NDIC versus Okem Enterprises. Indeed, the note of caution sounded by this court in Nasarawa versus State Specialist Hospital Management Board versus Mohammed on the imperative of treating or applying older case law authorities that predates the Third Alteration Act with extreme circumspection bears re-echoing here. End of quote. The claimant's rights have been violated. She deposed to the fact that she cannot get a job in Holland as a teacher again because any prospective employer requires a referral from Sterling School, and that in the circumstances, she cannot approach the defendants for a referral. That as such, she has been deprived of practicing her profession and has had to retrain in a new profession as a maternity nurse. Before her retraining, she could not work and had to depend on social benefits from the Dutch government. This evidence is unchallenged by the defendants. There can be no doubt that the claimant lost her source of income by the action of the defendants in terminating her employment. Her pride, dignity, and sense of self-worth have been injured by the actions of the defendants. Her contract was for 3 years renewable. Her annual gross salary was 4,500,000 naira per annum. I think an award of general damages, which she is entitled to, will meet the justice of this case. Consequently, and on the authority of Section 19D of the National Industrial Court Act 2006, I award the sum of 13,500,000 naira, being the equivalent of 3 years gross salary as general damages in favor of the claimant. For all the reasons given above, the defendant's counterclaim fails. It has not been proved and it is hereby dismissed. I also declare and make the following orders. 1, I declare that the determination of the claimant's employment by the defendant's letter dated 24th October 2014 during her maternity leave period is unlawful and is discriminatory against her on the grounds of her gender, pregnancy, and childbirth, and it is in violation of international conventions and the Nigerian labor law. 2, I order the defendants to pay the sum of 13 million naira, 500,000 naira as general damages to the claimants. 3, costs of 500,000 naira awarded the claimant on the main claim. 4, costs of 500,000 naira awarded the claimant on the counter claim. All sums are to be paid within 30 days. Thereafter, they shall attract simple interest at the rate of 15% per annum. Judgment is entered accordingly.
As the court pleases, we are most obliged, my lord, for this erudite and well-considered judgment. Just to note that in the course of the judgment, the plaintiff joined. I guess it was because of network glitches that she wasn't able to join earlier.
I'm sorry.
Thank you, my lord.
I'll record.
May I also, as a complicit? May I also, my Lord, thank my Lord for the judgment and for the far-reaching decisions that the court came to. May I try to confirm when the citizen of the judgment will be ready, because of particularly when my Lord has given a specific time within which to comply. And my Lord is also in Abuja, not in Lagos.
But the hard copies of the judgment should be in Lagos by next week.
As the company
should be in Lagos by next week. So I believe that it should be there together with the file before the Christmas, before the 25th of December.
Grateful to your Lordship.
File and everything will be sent to the Lagos division.
As a company.
As company.
Apply. But before then, as soon as the corrected version, because of course, like you know, there are typos and all of that. As soon as that is ready, the registrar of the court will send you a soft copy. She will send a soft copy to your email. The soft copy, of course, she will inform you, will not to just have signs there, while you are waiting for the hard copy to come from this division.
Grateful to your Lordship.
As copies.
The court will rise.
I think we can log out.